Welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice. It's always Rosie here. And as I've said many times, this is just a group of students and many young professionals who are very interested in anything that has to do with technology and, yes, it's regulation. So today I'm calling from Milan, where I'm celebrating my graduation. And I'm here to talk to my friend and colleague Giacomo Di Gregorio. Hi, Giacomo. Great to see you.
Hi, Rosie. Great to see you. And I'm calling as from Brussels as usual. Yeah.
You look very happy about that, but at least you're not alone from Brussels because our guest from today is also calling from Brussels, happily, I'm told. Hello, Rocco Saverino. Great to see you. Great to meet you.
Hello, thank you. Thank you for having me today.
It's a great pleasure to have you here. You were kindly referred to by a great friend of the show, Vincenzo Tiani, who is with us from Brussels again. Like he knows that we're here today. And I want to know, aside from telling us how you met Vincenzo, but tell us how you got to this point of your career. What led you into this specific path and why are you here today?
Well, I come from Italy, as you can know and understand from my name. I studied there for a while. More specifically, I studied at the University of Studies of Mediterranean in Reggio Calabria. And during my bachelor's in law, I started having my first experience abroad. Indeed, I had a couple of Erasmus studio and friendship in the University of Vigo and Granada, and also I stayed in Porto for a while. And this helped me to give a broader and European view to my bachelor's dissertation, which I also wrote thanks to of my course supervisor in Granada, who actually influenced my future trajectory in academia. Indeed, he sent me several PhD vacancies abroad. And to be honest, I just applied to the one that I got here in Brussels because of a serious reason. I applied to this vacancy. Among them, of course, the LSTS research group, of which I've been part during the last 3 years. And of course, Vincenzo is also part of the group. And, it's one of, I would say, well known in Europe for digital regulation, but in general for also I mean, the definition is law, science, technology, and society, so a very long name for the research group and broad expertise among the members. And also, of course, another reason is my supervisor, Gloria Gonzalez Fuster, because she's one of the most known professors in data protection. So when I saw that opportunity, of course, I applied. And last but not least, because of Brussels, with all the contradictions and the charm that make it very unique. And I must admit, at the very beginning, I would have pursued a career in the EU institutions instead of academia. While now I would stay in academia if it were possible, but of course, I'm doing my PhD here. So I'm in the last year of my PhD. Hopefully, I will finish this year. And yes, I'm here in Brussels. I'm happy to be here, and I'm happy to be here today with you.
Thank you. And I would like to be happy as you to be in Brussels, but I'm not that much. But yeah. Regardless of Brussels, let's talk a bit about serious things like your research. Like, what are you most interested in, and why does it matter? Just give us a general overview of what you're doing.
Yeah. Well, I, I have to start from what I love. I really love technology. So that's why since the very beginning, I wanted to connect it to law. So it came naturally to me to focus on data protection and AI. And like many PhDs during my journey, I decided to change the topic of my research from something that I decided to start at the very beginning, which was international data transfer, to a more to something more new, but also more challenging, which is the role of market surveillance authority under the AI Act and the potential fragmentation that we could experience in the future, not only in the context of cross-border enforcement among different market surveillance authorities, but also in the context of a cross regulation enforcement among different authorities in different fields. So, to answer to your questions, this matters. I mean, I would say that this research is important because if you think about the issue we had with the enforcement of GDPR and the inconsistent cooperation among different authorities involved in the enforcement in enforcement of it, I think we can have some problem also in the enforcement of the Act. This I think will be related to for both a more complex enforcement structure and because of the different approaches member states have been taking in appointing new authorities or designating existing ones, existing as competent ones. This has created a situation where you can have a completely new authority, like in Spain with AESA, the Agency for the Oversight of Artificial Intelligence. Also, you can have a sectoral approach with data protection authority superpowers as or superhero in this case as coordinator among the competent authorities, like in the Netherlands. Even though in this case it's not officially yet, while in the case of Spain, yes, because it was the first country that appointed a competent authority for the act. And then you can have a situation like in Italy, where Garante has been acting even before the AI Act came into force. For sure you will remember the decision against ChatGPT. Even though now the role is more limited to personal data matters and Annex 3 of the Act. The point is that when the proposal of the Act was published, many of us, and also ADPS and ADPB, with their joint opinion, and also the joint opinion was 5 of 2021, and there was also another opinion just from ADPS, 44 of 2023, and in both this opinion, the Data Protection Authority were identified as the market surveillance authorities. Why? I mean, not identified, but suggested as the market surveillance authorities that should be competent for the Act. This is related to the strict connection that there is between personal data and algorithms, for sure. And this strict connection could cause also some overlaps if the respective roles are not clearly marked. So I think a research on this is needed, not only for all the stakeholders involved, including the companies, of course, but also authorities that might have not clear yet and probably for a while what role they will play in the enforcement of the Act or in general when the enforcement of a regulation crosses into the field of another regulation.
A point that you highlighted is that algorithms and AI, of course, are highly dependent on data. And that's why the Market Surveillance Authority for the AI Act is likely and hopefully indicated in being the Data Protection Authority. At the same time, the AI Act is a product regulation. it looks like, or at least someone describes it as a risk-based approach that's typical of, for example, conformity assessment regulations, the ones that talk about the CE marking and so are related to products. And in that case, we have market surveillance authorities. Do you think that it's fair in something like an AI system, so a product by definition, that so much preponderance is given to an authority, the DPA, which is most likely to think in a kind of fundamental right enforcement approach and strategy?
Well, thank you for the question. Let's say in this case, yes. I mean, you mentioned a very important point, which is related to the medley nature of the act, because as you know, the market the AI Act is uh, let's say profoundly rooted to not only to the fundamental rights regulation, but also to product safety regulation. And we can see this from the legal basis, because we have Article 14. Article 114 of TFEU, and we also have Article 16 of TFEU. So that's why we have this hybrid approach also in the let's say the designation or the appointment of these authorities. But the problem here is also related to the fact that in the case of the Act, considering the complexity of this piece of regulation, due to the multi-use of the system, it's not easy to identify a specific authority in each country dealing with AI system in the market. That's why even if the deadline for communicating the official list of competent authorities was on 2 of August of 2025, a lot of countries failed to provide the competent authorities in time. Even in the case of the even in the case of the designation of competing authorities for protecting fundamental rights, the deadline was on 2 of November of 2024, and I remember nobody or very few countries respected that deadline at the time. So I would say that in this case it is more an habit, but I mention this because the double nature of the act, as I already mentioned. So among the authorities listed as competent authorities for protecting fundamental rights, there are data protection authorities in some countries, like in Belgium, Spain, and Netherlands, and no data protections involved in other countries, like in Portugal and Lithuania. Some data protection authorities will act as market surveillance authorities, meaning that they will be the major authorities at the national level in the enforcement of the Act, while others decided to entrust to governmental agencies. So here I would say that it's not easy, because always there will be this discussion about right-based regulation or risk-based regulation. And in this specific case, what I can say is that the market surveillance authorities are not new in the EU regulation, because from a purely enforcement authority perspective, the designated authorities should consider both market conditions and fundamental rights in enforcing the law for AI systems. And of course, the real enforcer of the AI Act will be the designated or appointed market surveillance authorities, also acting as single point of contact. The point is that market surveillance authorities are not new, as already mentioned. So in this case, there was an explicit reference to market surveillance authorities at EU level in a directive. I don't remember now the name, but it's the General Product Safety Directive adopted in June of 92. So in this case, the market surveillance authorities are indeed strictly linked to the EU product safety regulation, as clearly defined in Article 3, paragraph 26 of the Act, which aligns those market surveillance authorities with the ones of the regulation 2019-1020. And this regulation provides a framework for market surveillance and product compliance. So these aspects contributes to making even more complex the role of the market surveillance authorities in the Act due to the constant recall of regulation 2019-1020 for tasks and powers of this authority. So I would say that the challenge for me is to look at the current situation and wondering not only about cross-border enforcement about market surveillance authorities, but cross-border enforcement, cross-border regulation enforcement, where this looks also to other field. For instance, taking what you said about that, even though the act was drafted with the intention of not causing a prejudice in the application of the union competition law, the extensive powers granted to market surveillance authorities in accessing all documents, all documentation, training, validation, and testing sets for the development of AI system could also impact competition law. And this is especially relevant considering that market surveillance authorities must report without delay to the Commission and relevant national competition agency any information collected during activities that might be of potential interest for enforcing EU competition law.
Implementing the AI Act requires an even greater level of cooperation between the MSAs and DPAAs. Who are the authorities involved in supervising EU law-friendly AI, and how will they manage to find an agreement when their goals will differ?
Well, more or less, I already mentioned you that we have a different structure because, I mean, we have a different structure in the appointment and designation of the authorities, or I would say more correctly, different choices that the countries are making and they made. And this, of course, will affect also the enforcement of the act, because I think that if you have an institutional an institutional designation completely different in a country where you will have just one authority acting as market surveillance authorities, as in the case of Spain, or you will have a fragmented approach, a sectoral approach in the case of Netherlands, with the Dutch Data Protection Authority playing a relevant role in the enforcement of the act, but playing this role as coordinator, but also together with other authorities, because in the enforcement also um, the, 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 the authority for digital infrastructure in the Netherlands are competent. And then there are a lot of authorities involved. And then you have other countries where, for instance, you will see that this authority are in the end governmental agency, like in the case of Italy, where you have National Cybersecurity Agency. So you didn't appoint a new authority, you just use an existing ones. So the question is why you didn't appoint the Data Protection Authority. I think you didn't appoint the Data Protection Authority because, of course, there are some differences. If you look at the independence of the data protection authorities, of course, it's something unique. It's something that it's unique in the EU law because it's an independence that derives directly from EU primary law, from the charter, so and the treaty. So it's completely different that having a different authorities where the reference to independence, to acting without any bias and independently, it's from a reference that you can find in secondary law. And I'm wondering how these authorities can cooperate, can find an agreement when their goals could be different. Because of course, if there is a completely different structure, how they can cooperate. It's not the same that we saw in different in other regulations, like in the case of the GDPR, where you have the data protection authorities, and then you have the DPP. So you have this structure that is already well defined. Here, you also have something that is defined, but the different choices made at national level can influence, I would say, also the final enforcement of the act and the cooperation between these authorities. Because if you look at them at the Court of Justice, a decision of the Court of Justice regarding the case law on Meta versus Bundeskartellamt. I think I'm not sure the pronunciation was good, but I try. In this case law, the court stated that they should cooperate. They should cooperate by virtue of sincere cooperation. So Article 4 of TEU. But they have to do that without exceeding their respective competence. Because this could in some way cause some overlaps. But the problem again is that data and AI are inevitably linked, so we could see some overlap in the future, I would say. And then coming back to the authorities involved, and also a step forward for wondering about a cooperation about among these authorities. I would like to point out Article 79 of the Act, because in Article 79 of the Act is present the procedure at national level for dealing with an AI system presenting a risk. Indeed, this article outlines that in case there will be a risk to fundamental rights, the Market Surveillance Authority shall inform and cooperate with the authorities of Article 77 of the Act, so the authorities protecting fundamental rights. And in case there will be no compliance, and this no compliance is extended also outside the national borders, the Commission should be informed. And also the other member states should be informed. The other authorities competent in other member states should be informed. So in cases where, in this case, in cases where an agreement is not reached, for instance, about a withdrawal of a specific AI system presenting a risk in other countries, The Commission can intervene in the context of the Union the Union Safeguard Procedure, Article 81, and by entering into consultation with the competent authority and evaluating the measure applied by the authority. Based on the results of that evaluation, the Commission shall, within 6 months or 60 days, in the case of no compliance with the prohibition of the AI Act practice, referred to Article 5, decide whether the national measure is justified and shall notify its decision to the market surveillance authority of member states concerned. So the Commission shall also inform all the other market surveillance authorities of its decision. I would say, the ADPP binding decision of GDPR are somewhat replaced by this new role of the Commission. But we know that the Commission is playing a heavier role compared to the past in the new piece of legislation. We saw that also in the DSA. So.
Wow. It looks like from potentially from the perspective of a business then dealing of an AI system provider, for example, dealing with this puzzle, especially when they provide AI systems in different jurisdictions, for example, within the European Union, it looks like it's going to be difficult for them to follow the pieces and kind of fall within the right type of compliance, because then, already in the AI Act, there are norms that tend to be, I wouldn't say in contrast with each other, but like giving importance to different values. And different authorities will stress the importance of different values differently. So, and I'm also interested, and that's going to be my last question because I swear we will let you go. Do you see a potential kind of overlap in potentially a data protection authority deciding on something regarding Article 22 of the GDPR and a market surveillance authority deciding on compliance with the AI Act?
Well, yes and no. Uh, so, very good lawyer answer. Yes and no. Let me explain that. I would say that the data protection authorities already intervened in the past, with against this against the AI system. If we think about it, the decision of Garante to block ChatGPT in Italy, even before the AI Act became into force, so they have some powers and they already act in this case. And it happened the same with DeepSeek, because all the decisions we have, uh, they came from GDPR. They are not coming from, they are not coming from AI Act, and we already had some decision. And I think also in Germany, I saw that the Berlin DPA asked Apple and Google to delist DeepSeek under the Digital Service Act, if I'm not mistaken in this case, because it's not a classic GDPR ban. I'm not sure, because you see the intricacy of this of this research and also of this field, because it's as I mentioned many times, it's a cross-border regulation enforcement. It's not just a cross-border enforcement. We have to add this cross-border regulation enforcement, and I think it will be even more challenging in the future. And coming back to the decision of the Berlin DPA, I think also in Italy, in May of last year, we had such a request from Garante directly to the internet service provider. to block DeepSeek because basically they tried to block the DeepSeek, but it didn't work. But this was very informal. So in some in some way, the data protection authorities are trying. They tried, and they will try for sure in the future to to to, to apply GDPR. And I will say not to scream, but to make that others will hear their voice. But of course, if you think about it, for instance, let's picture, for instance, that market surveillance authority and data protection authorities are the same authorities. What are the advantages here? Unified expertise in fundamental rights, impact assessment, streamlined internal coordination for overlapping compliance requirements, reduce administrative burden for regulated entities dealing with a single supervisory contact, and of course, a coherent interpretation of intersecting legal provision when we are talking about data protection and AI. However, this consolidation could generate also a significant risk and challenges because we know that data protection authorities are face substantial resource constraints and also extensive workloads of under the GDPR. So if we had also the Act responsibilities, I'm not sure this will work properly. But again, as we already said, the Act, it's if we should give a percentage of product safety regulation or fundamental rights regulation, I'm not sure what percentage is higher, you know, because if you look at the recalls of market surveillance regulation, I mean, to the regulation 2019-1020, and to the other recalls that are made in the Act, I would say that it's more a product safety regulation than a fundamental rights regulation. And this is also a problem, you know? This is also a problem because, yeah, okay, it's not it's like that. It's more a product safety regulation, but then these products are not just product. This product will, I mean, can cause some harms, can have some strong consequence to fundamental rights. So that's why it's very difficult. It's very difficult to have a clear overview of that, and that's why I'm struggling with this research. You know.
I can feel your struggle, especially because yes, okay, you give importance to fundamental rights, but obviously data protection and privacy is not the only fundamental right that's being impacted by an AI system. I mean, even the right to a clean environment is impacted by the massive use of AI. So it's really interesting what you're doing, and we really are grateful that you came here today to talk about it, because although it's a long conversation to have, I feel like the most important kind of pillars of the structure of this conversation have been set, and it's an open problem. And I can see why your PhD is taking the right time to be completed because it's impossible to understand all of these intricacies and this labyrinth of authorities and competencies. Well, thank you so much, Rocco, for joining us today. It's a Friday evening, everybody. Like, just saying, he's here at 6:20 recording Legal for Tech, the podcast. You deserve a prize just for that.
Thank you, Noah. Thank you for inviting me. And yeah, of course, apart from the topic I choose, that we should also consider that it's, you know, a work in progress piece of legislation, even more with the digital omnibus now. So let's see what happens in the future. But thank you for giving me the opportunity to talk about it. And thank you for this fantastic podcast because I think it's very, very interesting for everyone who is interested in data protection. But I would say for everyone in general, because it's very interesting also to know if you are not working or studying these kind of things. I think it will be worthwhile to listen some very interesting and fruitful discussions.
I have to tell you that we are on top of 79 people's list on Spotify, which is, I think, amazing knowing that we're number one in their choices. I think it feels that we are a closer community than we thought. So thank you very much for the tiny plug. Can we also invite you to, if you want to share something with our audience, something you maybe are working on, something that they should give a look at, please feel free. We will add the link in the show notes if there's something you would like to share.
Yeah, okay. Well, I wrote an article on Digibeetle platform. So in this case, I think you should have a subscription, but it's a comparison. It's a very, I would say, basic comparison between market surveillance authorities and data protection authorities. And I'm working also on the independence of data protection on a piece of paper on the independence of data protection authorities and the designation of market surveillance authorities among Netherlands, France, Italy, and Spain, but this is not still published. So stay tuned and probably will be published soon, but it's not yet.
Good. Then we'll keep them tuned for you. Well, thank you so much for joining us today. Thank you, Giacomo, for helping me. It was great to see you today and enjoy Brussels on Friday evening. Um, this was all from Legal for Tech, the podcast.